Because if you don't have a plan in place, then the government will put a plan in place for you.
Today, I've got Chris.green, estate planning attorney, with us today. Chris, how are you?
I'm doing well. How are you, sir?
Good, good. So, Chris, thanks for coming on. And before we get too far into this, I want to ask you, where are you located right now?
Well, Nate, I'm not sure if you can find me, but I'm right next door to you, on 805 New Hampshire. We're actually building neighbors.
Yep. So, yeah, he's in the same office as we are. And, you said, if I can find you, funny story on not being able to find stuff. You're married, right? So you can probably relate to this, or unfortunately, your wife can probably relate to this. Have you ever stood in front of the refrigerator and not been able to find whatever it is that you're looking for? Your wife knows exactly where it is, but you just seem to have all kinds of trouble finding it. I had that trouble with ketchup one time. Ketchup is a big, bright red bottle, and for some reason, I couldn't see it. So that's luckily, though, I can find you in the office, so that works out great. So we're going to be talking about wills and trusts today. And so we've brought Chris on here as an estate planning attorney to answer some of those questions for y'all out there. And so to start off, I'll just start asking probably the biggest question, maybe the most frequently asked question, Chris, is what is a will and a trust, and what are the main differences between them?
A will is a document that states who gets what and who's in charge of making sure that happens. People named in your will who will receive your assets are called a beneficiary or an heir. And the person in charge of making sure that it happens is called an executor or a personal representative. Now, it's important to note that jointly owned property or assets where you designated a beneficiary are not included in the will. So assets when you designate a beneficiary would be a life insurance policy, retirement account, IRAs, that sort of thing. Mm-hmm. Wills are public. They have to be filed with the probate court. They take on average about 6 to 18 months on average. And a trust is a private document and where you don't will, after you pass, the person in charge of your trust, naming your trustee, would not have to get permission from the court in order to get the process started and get the assets to your loved ones.
Okay. So I've often said that, if you have a financial account, like you said, an IRA, or there's a brokerage account, they've all got beneficiary designations on them that supersede any type of a will or a trust. And so when would be the case that, say, a trust or will, like, are they always needed, a will and a trust, or are there scenarios where they definitely are needed and scenarios where you may not actually need a will or a trust?
So every person is different. And the word estate really just refers to what a person owns. So then the question becomes, do I have a plan for what I own? And if you do not have a plan for what you own, then you probably need an estate plan. Now, I could probably answer this question better by posing a question. So I would ask myself, do I have a will or trust in place? Mm-hmm. Do I have a durable power of attorney? Do I have a healthcare power of attorney? Do I have minor children? Do I know what would happen to my minor children if something were to happen to me? Do I know what would happen to my assets if something were to happen to me and my spouse? Can my unmarried spouse speak to doctors on my behalf if something happens to me? Do I know what would happen to my assets if my surviving spouse remarries? And do I know what would happen to my assets if something happened to me and my spouse? If you answer no or I don't know to any of these questions, then you probably need an estate plan. Or if you are unfamiliar with some of the terms that I mentioned, then you probably need an estate plan. Because if you don't have a plan in place, then the government will put a plan in place for you.
And that plan is probably not going to be as good or as, what's the word I want to use here, as beneficial for you, or as, it's not going to be the one you want. I'll put it that way.
Not going to be the one you want.
Probably not. Probably not. So yeah, and you did say something about if you're unfamiliar with any of the terms that you mentioned right there, that means you probably should have some type of an estate plan. There's a couple of them that I know a lot of people are wondering about, and that was you named a couple different powers of attorney. So do you want to take a couple minutes here and explain the difference between the powers of attorney and why you would want to have that specific one in place?
Okay. So the first one I mentioned was the durable power of attorney. And that's a kind of a fancy term of who's in charge of my assets in case I'm incapacitated. So not always referring to death, but if you're in a coma, something like that happens, who's responsible for paying your bills? Who's responsible for going to the bank for you or writing a check? Someone you trust, that would be the person that you assign a power of attorney. Now, in healthcare power of attorney, it's different. It's kind of you're giving someone that power again, but you're giving them the power to make medical decisions when you're incapacitated on your behalf. Again, it's someone that you trust, but you want someone who's able to make those decisions. You've already had a conversation with them. And also you want to have a HIPAA directive, a healthcare directive with them in place so they can speak to doctors about your prior medical history as well.
Okay, awesome. And so there are, we have different financial accounts here that could either be trust owned or possibly have the trust as the beneficiary. What would be a scenario where someone might want to have a financial account be owned by a trust, or what might be a time where they don't want it necessarily to be owned, but the trust could be the beneficiary?
That's a good question. So one of the most common examples that kind of jumps out to me, that I see, it's usually the life insurance policy. So if you're married, you would probably designate your spouse as the primary beneficiary of your life insurance policy. Now, and then you would name the children as next in line for the benefit. Now, that's okay so long as so nothing happens to your surviving spouse. But if something happens to both of you guys while your children are minors, then what happens is that the life insurance policy won't pay out directly, and the kids will be in court, and the court's going to assign a conservator over the children's money until they reach the age of majority. And once they reach the age of majority, they're going to pay your kids out at 18 years old the full amount at once. And I don't know about you, but when I was 18 years old, if someone gave me hundreds of thousands of dollars all at once, they probably want to end it well. So that's a scenario where you want to name the trust as a beneficiary as opposed to your minor children.
Okay. So that's definitely in the case where the vast majority of my clients tend to be those that are baby boomer age or seniors, call it in their 50s, 60s and above. And so their main spouse or their main beneficiary will be their spouse. But then after that is probably their adult kids. But then adult kids after that will be their grandkids. And so the grandkids are going to be most likely minors in that case. And so it still could benefit even them to have some type of a trust set up in case something like that happens. Or even if they wanted to give money to their grandkids, then probably a trust would benefit them in some form or fashion.
Yeah, you're correct, because once you set up the trust, you're going to assign the trustee, and then the trustee will have your instructions that you've outlined in your trust that they can follow. So if you designate the trust as the contingent beneficiary, now everything that's in that account will go inside the trust and will be managed according to your wishes after you're gone.
Okay. Yeah, I have heard a lot of times that trusts are a really good tool to help control the assets from the grave. Is really
right.
And so here's a question, because now we're talking about trusts, and there's a few different type. I think the main two that most people will think of would be a revocable or an irrevocable, or if you want to get fancy, they call it irrevocable, just potato on how you pronounce that, right? But what would be the main difference between a revocable and an irrevocable trust?
Well, an irrevocable trust would mean that that trust is locked in. You can't make any changes. And revocable, meaning that you can change it at any time. So when you hear the term revocable living trust, we're talking about a trust that, you can change when you want to. And then even within those trusts, revocable or irrevocable, there's different phases. There can be trust concerning your minors. There could be special needs trusts, just so many different trusts, but it just depends what you want to do. It's always client specific, but you definitely want to trust that you're in control of now while you're sound mind and body, and that will keep your loved ones out of court and conflict after you pass on.
Okay. Yeah. I would guess, maybe the statistics on this, that the vast majority of the trusts that would be set up would be the revocable.
Absolutely. Because it provides the most flexibility.
Mm-hmm.
Once you, and even in the revocable trust, you can set up things for asset protection that would be irrevocable, but you want to start with that revocable living trust, because like I said, you can make changes at any time.
Okay. Yeah, and in the irrevocable, that one, correct me if I'm wrong, is that the one that we normally would want to set up if somebody could possibly be coming up against some of those estate inheritance tax limits, so that they can get assets outside of their estate? Because now, once you put it in the irrevocable trust, you basically lose access to it. So it's no longer part of your estate. So you could avoid some of those estate tax ramifications, I guess.
Correct. And I mean, you want to use that in scenarios, again, specific to you, but the irrevocable trust concerning taxes, or again, because you no longer have access to it, so it doesn't apply to your taxes. But also, sometimes, you have children, and even adult children with special needs. So you may also want to put that in an irrevocable trust to protect those assets when concerning Medicaid and that sort of thing.
Okay. So we've talked about several different types of trusts right now. And so how critical is the wording of the trust? Because, I mean, we're talking about law here. And so sometimes things can be interpreted different ways. So how important is all of the wording with the creation of trusts?
Okay. So a trust needs to be drafted with the utmost attention to detail. And the person drafting the trust has to understand the reasoning behind the wording. So you'd be surprised how many people come in my office and they have a trust that's 1 year, 10 years, 20 years old, and they believe that, hey, I just need a couple of changes to update my trust, only to find out that that trust hasn't been properly funded, meaning that none of the property that they have was retitled in the name of the trust. So what they essentially have is an expensive document that will almost certainly land their loved ones in court after they're gone, which wasn't the intention of the trust. So you have to be careful when you're drafting the trust, and it's always good to seek legal counsel.
Okay, so you're saying that there's even an additional step once someone gets the trust created. They can't just sit there and say, I'm done, right? It's like, now that they have this trust, they have to go about titling things in the trust. And that's where you and I work together a lot, is if somebody has their assets with me and they're looking to get them retitled as trust owned, or make the trust a beneficiary, that's where it's a very simple process for us to be able to do that.
Absolutely.
Okay, perfect. So now, yeah, so you don't end up with that expensive document that doesn't actually do anything. Good deal. And that's an important thing to have, is financial advisors and estate planning attorneys working together as part of your advisory team. We'll put that under an umbrella because, yeah, we don't want those scenarios to happen because if you've just got maybe an estate planning attorney working on an island without having a close relationship with an advisor, that can happen a lot, in my opinion. You've got a great expensive document, but it didn't actually do anything for you. Right? Do you run up against that, or have you seen that in your industry? Unfortunately,
Absolutely. It's quite common. Sometimes people may go online and download a trust document or will from software, and think, hey, I checked the box, and then you have a conversation with them and what they're really trying to do. I get in my office, I get to pose those questions that they didn't ask themselves. And, we find out, what's missing, what gaps, what holes can be filled. So, not just an estate planning attorney, but working with a financial advisor also helps.
Yeah. The classic case of not knowing, you don't know what you don't know, and therefore they don't even know the correct questions to ask when they're creating their own legal Zoom document or whatever the heck, that they ended up going to get it. So, all right. Well, I think unless there's anything that you can think of at this point, I think we've covered a pretty broad range of topics here on this first video. And we'll probably, if we want to get in depth into some more very, very specific estate planning situations, we might bring you back on to go over those in the future. Okay. But yeah, unless there's anything else that you would like to go over or like to have me ask, I think we might be good for today. What do you think?
No, that was great. That was great.
Okay. Well, perfect. Well, thanks for coming on, Chris, and
right.
for all those that are out in listening to this. So yeah, if you want to take advantage of Chris's services, once again, you know exactly where to find him as far as the physical office. Chris, what's a website, or do you have an email address, phone number, anything like that where people can reach you as well?
Yeah, my website is gransonlegacy.com. That's GRANSON legacy.com. And you can reach me at 913-738-6597. If you want to give me a call. If I don't answer the phone, I'll get back to you within 15 minutes. So again, gransonlegacy.com. I have different social media formats and platforms that you can reach me on. Otherwise, just come to Nate's office and knock on my door.
Sounds good. And we'll make sure to link to all of that in the show notes or description, wherever it is that you're finding this, either on YouTube or the podcast channel and everything like that. So yeah, I guess that's it. So Chris, thanks for helping rescue some retirements, and everybody listening, we'll look forward to seeing you here again in a week or so when we bring out more content, because we're always trying to empower you to live the retirement you deserve. Take care.